Linda DeFries, Special Education Law Presentation Video, August 16th, 2020. Prior to the 1970s, the perception society placed on persons with disabilities consisted of two models of thought, qualitative and quantitative. Qualitative model of thought entailed the idea persons with disabilities were deviant or not normal. Quantitative model viewed those with disabilities as persons who learn, develop, and function differently, slower or in some restricted way, but still progress. Another way people with disabilities were viewed by society was nature versus nurture. Nature was viewed as conditions that were fixed or untreatable, whereas nurture were persons with disabilities that were teachable through education, training, and life skills could become productive citizens. Spalding and Pratt, 2015. Subsequently, there was very little consideration given to persons with disabilities regarding education. Most persons were institutionalized or hidden from society. From 1970s to present day, due largely to parent advocacy groups, great strides were made towards educating the disabled. According to the U.S. Department of Education, in 2010 article titled 35 Years of Progress in Educating Children with Disabilities Through IDEA. In 1970, 1 out of every 5 children with disabilities were educated in schools. The Pennsylvania Association of Retarded Citizens versus Commonwealth in 1971 and Mills versus Board of Education of the District of Columbia in 1972, court decisions reiterated that every child with a disability had the right to be educated, thus leading to the passing of Public Law 94-142 that guaranteed all persons with disabilities receive a free and appropriate education, public education. This is the U.S. Department of Education Office of Special Education and Rehabilitative Services in 2010. Parental involvement in judicial decisions about parental rights and student education rights in public, charter, and private schools. Jacob Winkleman versus Parma City Schools on May 21, 2007. The issue addressed was whether parents can legally represent themselves on behalf of their children in court proceedings. The court recognized that parents have an invested interest in the educational decisions regarding their children with disabilities. What's the significance of Winkleman? No date, rightlaw.com. Resources to stay up to date with current legal trends in special education include ada.gov, Individuals with Disability Act, IDEA, special education and IDEA resources from the National Education Association.gov or .org. Special education resources and links for parents and teachers from specialeducationguide.com and Special Education Services SES from the Utah Board of Education, utahschools.gov. Educational Equality, also from www.schoolsutah.gov/education. 2 court cases about parental rights and student educational rights. Case 1, Schaefer versus Wiest, November 14, 2005, a ruling by the U.S. Supreme Court addressing who is responsible to provide the burden of persuasion when arguing if an IEP is adequate or not for providing services to a child with disabilities. Yell, Ryan, Rosalinsky, and Katasininas, 2009. Case number 2, Arlington Central School District Board of Education versus Murphy, 2006, addressed the recovery of expert fees to prevailing parents in IDEA disputes, referencing an earlier case, Board of Education versus Rowley, in 1982, addressing the appropriateness of service provided students with disabilities and the IEP Individual Education Plan. Yell, Ryan, Rosalinsky, and Katasininas, 2009.